All right, let's start. This is Scott Trowbridge with the Capacity Building Center for Courts, and happy to see so many people on this all call today. And today we will be talking about hearing quality. This is not a new topic for CIPs, and it's something that in the last year we've had 2 CQI workshops on hearing quality, and we've seen a new PI focusing on that. So this will be some updates and some new information that we've learned. We'll hear from 2 states, and we will have a good amount of time for question and answer. And I know people have been doing some states have been doing some recent thinking about this, so we really want to make sure we have time for that. I'm not seeing there's a few people I chat in the attendees list that I'm not sure who they're identifying, but mostly I'm seeing familiar names. But quick tutorial for anybody that might be new to this Adobe environment. We have these different windows, and you'll see them move around, but that's expected. That's part of the plan. One other thing that can be useful is if you mouse over anybody's name there in the attendees box, you'll have the option for a private chat. So that's very much encouraged, because we know there's lots of people on here with different expertise and people working on different things. So you might see somebody in the general chat say something and say, oh, I need to connect on that, or I want a copy of that. So go ahead and use that. The main chat we will save, and we put these on YouTube for people to see. But the private chats, those are really private. We can't even see them with our administrative functions. If people could mute their lines when they're not speaking, it's *6. And I think that's it. I have to test the chat function and also just pick people's brains in a way I hope is helpful. Is we have one question to start off with, which is, what is one super efficient idea you've had to improve hearing quality or conduct CQI around hearing quality? If you go ahead and type that in the chat, please. All right, I see a few more people typing, but I really want to try to stick to the clock as much as I can. As I said, I know people have had some questions. We've been getting questions over email on this topic recently. So let me turn it over to Dr. Alicia Summers and switch screens here. Should be able to control the slides, but let me know if you're having trouble.
Thank you, Scott. Hi, everyone. We wanted to start, before we get into some site specifics for you, we wanted to talk a little bit about what we know already about hearing quality. We've done some work around it. Several of the agencies that we've worked with have done work around it, and as I'm sure you know, many of the CIPs many of you have already done some work related to examining or improving hearing quality in your jurisdiction. So this is going to be a brief overview, but it's going to try to give you a sense of some of the work that's been done in the field and some of the research that's been done and what we've learned so far. We just got your self-assessment recently, and we always do an analysis of findings to see what people are working on and try to share the information in a meaningful way. This is just from the self-assessments that were turned in for fiscal year 2016. And you can tell from the map here that the majority of states had a project on hearing quality during that time frame. And we define hearing quality within the self-assessment results pretty broadly, as I'm sure you know, in terms of a variety of different projects. But all but 7 states had a project that they identified in the last time frame. As Scott said, with the new program instructions, clearly everyone's going to have some work around this, so we expect this whole map to be blue next year. But this has been a project that's been kind of at the top of the list for several years. The majority of states are doing something in this area. And in the last fiscal year, those projects were primarily process improvements or court observation work to collect data on what's occurring in practice. There's also been some work around, we have several states doing specialty or pilot courts, improving their court orders, or examining mediation, but you can see 57% here are either process improvements or court observation. In addition to this, last year we had several states and the year before who, when we asked you to identify some of your high resource priority projects, identify hearing quality as some of the main projects that you were working on. We outreached to the people that had done structured court observation in the fiscal year 2015 and listed it as a priority project. I'm sure those of you who are on the call remember getting contacted by someone on the research team to say, can you tell us a little bit more about that? Well, we compiled all that information into a document that you can find in the Files pod. It's called the CBCC CIP Hearing Quality Summary. And what that is it identifies some of the states that had a priority project around this, what they looked at, and what some of their findings were. So if you're interested in learning a little bit more about what others have done and what they've looked at, I'd encourage you to download that document. It will be available on CIP Share shortly. It's still in Word, and we typically try to PDF when we finalize the documents, make sure they're ready to go on the website, but it is a final/near final product if you'd like to learn more. And again, it just hits the highlights of some of the states that had done this work, offered to share data with us and let us know what some of their findings were, so that that's something others can learn from in the field. We've also learned quite a bit from some of the empirical research on this. And when I say empirical, what I mean is something that's been published. Unfortunately, with a lot of the work with the court improvement program, there's a lot of great work in the field, but it doesn't get disseminated. It doesn't get shared in a meaningful way, and so others don't know about it other than through forums like this. So we don't have reports. Or we may not have papers to learn what you've learned about hearing quality or how that might be related to outcomes. So we try to take a look at what we know from papers that have been submitted to peer-reviewed journals for publication. And you can imagine child welfare court processes are some of the least reported in academic journals. There's not a whole lot out there to tell us what works and what doesn't work, which is why it's so important for the CQI process to be integrated into everything that we do, so we're learning from each other, so that somehow we're getting this information out there. There have been a couple things, however, that we've learned for this process. One, we've learned that people define hearing quality differently. The research on hearing quality has examined a host of different variables. This list on your screen is not inclusive of everything that's been collected, but some of the primary things that we've seen people look at in the articles and the studies, evaluations that have been done. Hearing length is a common variable. People look at how long does it take. In part, that information is useful for thinking about docketing and cost. How long does it take? But also, how long does it take to do this well, to do the things that we'd like to be able to do, to engage the parties, to have meaningful discussion? How long, what's our minimally sufficient number here to be able to achieve these things so that we can figure out how to do this more efficiently and more effectively? So hearing length is often examined. We also want to know who's there and how they're participating, both the professional stakeholders, how early are they being appointed and present at the hearings, as well as the parties, parents, youth, the tribe, foster parents, relatives, others who might be involved. A lot of the research looks at, it's kind of a basic yes-no variable, but it gives us a lot of good information. And then how do they participate in the process? The research often examines what the judge is doing, judicial behavior on the bench. How do they engage parents in the process? How do they engage youth? How do they explain the process to others? Do they give people an opportunity to be heard? Do they make a lot of inquiry around key topics in these areas? What kind of findings are made on the record, or what kind of orders are made on the record at these hearings? And then there's several things around discussion at court. What is being discussed? How much is it being discussed? Are they discussing everything that's statutorily required, everything that's recommended from a best practices perspective? What does that look like? Do they have expert witnesses when they're needed? And then beyond just what's occurring right now in the court process, there's pieces of the entire process that might be related to having a high-quality hearing. And that might include how they're being docketed, whether continuances are allowed as part of the process, how many different judges might touch the case. And even though that's not a specific, I can tell that right now while I'm in court, it is part of a process that can contribute to having higher quality hearings. So these are a couple of the pieces that we've looked at. The research has also examined some related to quality legal representation, which is considered an element of a high quality hearing, but kind of goes beyond the scope of some of the studies that we're going to look at today. The methods used to examine court have varied. You could imagine court observation is one of the most popular. That's because if you want to look at practice, what's going on in the hearings, observation is a good way to do that. In observation, you can go in and see automatically who's there, what's going on, what are they talking about, how are they talking about it. You can get a better sense of the process through direct observation. So it's one of the easiest ways to examine the court process. But it's definitely not the only way. And sometimes it's hard to do because it's not feasible or practical to do with the courts. So other methods that have been used in the research include case file review. You can imagine file review gives you a longer look at the case. If you come in and observe a hearing, you're just looking at one point in time. If you look at files, you can see the case across the life of the case, which includes continuances. How many hearings are continued and how many continuances are there? How many different judges are there across the life of the case? Who's present across the life of the case? You might come into a review hearing and parents are present a lot, but if you look at the case, maybe permanency hearings are less frequently there, or shelter care hearings. So you can tell more about the life of the case and some things that you may not be able to tell from court observation. Others have also used surveys and focus groups. Multi-method approaches, I will say, as a researcher, are a great way to go to give you more robust information about what's going on. But surveys can tell you things that you may not be able to do. If you don't have the resources to go into all your jurisdictions and observe court, you can send online surveys and ask them some of the questions that you would want to know. How frequently is this occurring in your court? Now, it's not directly observable behavior and it's someone's guess, so it's perceptions, but it does give you an opportunity to collect data with little resources and in more sites if you don't have the ability to do that. So surveys are a good way to ask some of the same questions, but also people have used them to gain understanding about what people think about the process. Do you think children should come to court? It's a great question if you're doing observations around how often youth are present. If you learn from your stakeholders that they don't think they should be here, that's a good explanation for why. So your surveys and your focus groups can often explain the why, whereas your file review and your court observation can often explain the what a little bit better. They can give you that context. And I often recommend using them either before you build a tool to know what you should build your tool around, or after for context to better explain what you've learned. In the research, we've seen use of all of these different methods. The research is also pretty limited in terms of linking quality to outcomes. I wanted to talk briefly about how we've seen that so far in the research, and I'll talk some about it in just a minute as well. One of the things I know most of you would like to be able to do is say, here's what a high-quality hearing is, here's what our hearings look like, here's why it matters. Because just saying, hey, here's a list of things you should be doing differently is not a good sell to people to say this is going to affect children and families. But if we can link what's going on in court practice to positive impacts on children and families, that's going to be important for us. The issue is it's challenging to do. Most of the work that's being done in the field and the courts is very descriptive in nature. And descriptive data is really talking about what's occurring. What does practice look like? What does the process look like? You get averages of behavior or percentages of how often mom's present, but that doesn't tell you how that relates to outcomes in the cases. Taking it to the next step is what we'd like to eventually get to so that we can pinpoint what is the most effective thing you can do in court. If we can identify one thing that above all else makes a difference, that's going to be important to us. In the research, we've seen that in a couple ways. One way to look at it is if you have the right data sets and you have quality indicators on a case, and you follow those cases to case closure, you can do predictive analyses with your early hearings and say what from this first hearing, how often somebody was present, what the discussion looks like, how the judge engages parties, which of those predicts reunification, which of those predicts time to permanency. You can start looking at predictive models. You have to have the right data and a data analysis person who can run those analyses for you. That's one of the most robust ways to do this, but it's more challenging because the data takes more resources to get. Another way that you're going to see when we start talking about this work that has been done a couple times in the field and by some of the court improvement programs is looking at typical practice and typical outcomes. And what I mean by that is you can take an average. What does your average hearing look like in terms of time? Well, average hearing length might be 15 minutes. The average time mom's present is 67%. The average number of topics that get discussed might be 54% of these eligible ones. That gives you an average for a county. And that county also has outcome averages. 47% of cases result in reunification. 50% of cases are in care more than 2 years. You have all these numbers. Well, you can run correlations, and it's just relationships, but see if the jurisdictions that have higher quality also have better outcomes or different outcomes. And that's some of the ways that we've been able to start linking these. It's not always the most robust way, but it gives us important, valuable information that we can follow up on. And the question that was asked to you earlier, in thinking about efficiency or effectiveness, how can you do this? I know most states don't have the resources to go to every single court and do structured court observation and then analyze all the data. And analysis seems to be the sticking point for a lot of people. So thinking about that, there's a couple things that I always recommend. One, if you have some kind of platform where you can do surveys, I just put SurveyMonkey on here because it's fairly inexpensive, about $300 a year. You could do your court observation in court on a piece of paper and then build a survey that looks just like that. Enter the data that way, and SurveyMonkey analyzes the data for you if you only want descriptive information like averages and percentages. You can do the same things with Google Forms. It's free. Create a form with the questions that you want. Put that in Excel. And if you know how to create graphs in Excel or do averages in Excel, then you have a way to look at the basic pieces. If you want something more robust, I always recommend university partners, and we can talk more at a different time about what that takes and the pros and cons, but it's definitely an option to think about with your hearing quality work. In terms of what we've learned, some of the pushback that we get from the states is that we shouldn't have children in court. There's been some concern around that. But what we've learned from this, a study that was done by Vicki Weiss and some of her colleagues, is that they started surveying youth that came to court and youth that had not come to court. And they found that they actually, when they come to court, there's more positive feelings about the court, no evidence of stress. The kids are under some level of stress. They're in foster care. And so, but it wasn't different for the ones who came to court versus the ones that had court but didn't come in terms of their stress. The judges were more engaging of the youth. It was related to more positive feelings by the youth. And then there was some stress when the fathers were present in the hearings, but it wasn't lasting. So we have some evidence, and there's some other studies we can point you to as well that have identified that the process is not stressful on youth and that they feel positively about that. And engaging parents and youth is often an outcome that we're interested in within the system. We've also looked at some outcome factors like how often are children or youth placed with parents or relatives. In this particular study, we were examining typical behavior at the first hearing related to case outcomes, and we looked at only early hearings in the process. What we found was that judges that are more engaging of parents also were more likely to place with parents and relatives the next hearings. And there's lots of reasons why this might be, but part of it might be if you engage the parents in the process, they might be more likely to open up and identify potential relative resources so that they can be placed there quicker. Whereas if they're not engaged in the process, it's unlikely that they'll be as cooperative. Researchers also examine timely permanency. These have been really interesting findings in terms of if there's a lot of breadth of discussion in the hearing, judicial inquiry, parties being present like children's attorneys and moms, and if there's good discussions of efforts to reunify. As these things go up, the time to permanency actually goes down. So the more often that these things occur in courts, the less time it takes for the children to achieve permanency. And these are compiled from multiple studies, but all of them looking at the typical model that we talked about earlier, what typical process looks like. We've also examined percentage of reunification, the likelihood of reunification in a case. And we found that the discussion at the very first hearing, if you have a robust discussion at your preliminary protective hearing, that's a predictor of reunification. The better discussion there is, the more likely the case is to reunify. Also, having parties present at this hearing, the early hearings on the case, there's a higher likelihood of reunification. And these studies looked at more of those predictive analyses I was talking about earlier to say there's more of an opportunity for reunification to occur. There's also research from some of the CIPs that demonstrates correlations in the same areas related to those jurisdictions with higher rates of reunification also engage in some of these different practices, including having the children present at court and specific discussion. And looking at percentage of youth still in care at 24 months, again, this is that typical behavior where we're doing the correlations and relationships. We found that discussion of efforts to reunify and having the child mother or father present were all related. So the less likely that those were to occur, the more likely the kid was still going to be in care at 24 months in two different jurisdictions, in two different states, multiple jurisdictions when we looked at their data. I'm going to go back real quick and just say that's most of what we know right now about hearing quality. There's been some other findings that are not out in the peer-reviewed circle yet, but pretty interesting around the quality of discussion at some of these hearings and predicting these outcomes. But the reality is there's still a lot that we need to know. And part of our work is really to help you guys figure out what you would like to know and how we can help you learn it. And so that can contribute to the field and we can continue to grow this work. Now, as part of that, as Scott said earlier, we've done a couple CQI workshops now around hearing quality work, one in Reno and one in Chicago, really focused on one-on-one learning, peer learning, and going through the change management process, the CQI process, to learn how to move this work forward in a meaningful way. And I think up next we have a couple of the states who participated in that are going to talk to you a little more about their hearing quality work. If you have any questions for me, I know we have time at the end for questions, but feel free to type them in the chat box, or if you're interested in any of the citations for this, I'm happy to share those as well.
Okay, thank you very much. Going to go on to, I think we'll save all the questions for right now until after the two states go. And we're picking on Nebraska and Oklahoma today, and we're asking them to go through, explain what their project is, but also go through some of the early CQI steps. And we're picking on them in part because they came to CQI workshops, and so we had one-on-one interactions and sort of identified these as maybe being interesting things that other states might want to think about, especially, given our preliminary review of all the applications that came in. So I think we're Katie Bass and Marianne Harvey. Are you there?
Yes, we are.
Great. So you were just going to present. I wasn't going to interview you, correct?
Sure, that works.
Okay. All right.
Oh, let's see. Are we sharing screen? Let me. Okay. So our project is a court observation project. And we are really focusing on, let's see. I'm not sure. I put together some slides. Let me see if I can open them up really quickly.
Okay, sorry.
That's all right. I don't think that's going to work. So I'm not going to worry about the slides. So ours is a court observation project that looks mostly at issues relating to who's coming to the hearing and how engaged they are, if we're talking about the judiciary and our attorneys, how well they're engaging with clients, and then also general preparedness, whether our caseworkers are prepared, the attorneys seem prepared for the hearings. And when we think about sort of the phases of the CQI project, so if we think about when we started, we really started as kind of a pickup project. So our entire staff turned over the last year and a half. And the previous CIP team had been working on a court observation project. We'd been hearing people asking us if it was something we were going to pick up. And so we decided we would. So when we think about those stages of the CQI project, we kind of went backwards. We started with, here's a project that's being handed to us. But then we went ahead and tried to take what the previous group had done and tailor it to what we see as the needs of our court system right now and what we really want to focus on. So we really, like I said, wanted to focus on these quality issues. We were hearing anecdotes from some of our stakeholders that caseworkers weren't prepared, that children were no longer coming to court in the rates that they used to. But we don't actually have the evidence for that preparation, for some of that engagement stuff. And so when we look at ours, we are really thinking about, I'm sorry, I lost my train of thought here. When we're thinking about this, we're thinking that this is a baseline at this point. There isn't an intervention that we're measuring a before and after right now. What we're trying to figure out is, where do we need that intervention to be? We know that it's there, that there are issues, but those are all anecdotal, and we want to make sure we have the evidence and that we're doing targeted outcomes when we, in fact, implement some sort of intervention. So some of the groups we've worked with, we work very closely with DHHS, our Child Welfare Administrative and CIP teams meet on a regular basis. We meet every 6 weeks, and they helped us to really formulate our tool, gave us some ideas, things that we thought made sense to measure. They asked us to maybe measure something else and make sure that we're including them in these feedback loops. One good example of that is that we were planning on measuring who was offering which exhibits, and they had suggested instead talk about having us measure whether or not those exhibits were being discussed during the hearings, because maybe everybody's just assuming everyone read it. So we changed our tool to sort of focus on the things that they were saying were probably bigger issues in court. We've also recently started working with our foster care review office, who has stakeholders across the state who may help us actually do some of the observations, so that we're hoping we can train their employees who already have to be in court for a certain number of hours, and they may be able to use that time to produce some of our observation data for us if we can get them all trained up. So that's a really exciting opportunity we found. Like I said, there's really no intervention, but when we think about that phase 2 and developing a theory of change, I would say that is where we felt like the CQI workshop was most helpful to us in articulating what our theory of change would be. We had these really general ideas, like we want more kids in court, we want better engagement. But in working with Stacy and with Alicia on that theory of change, I felt like we were really able to say, here's why we're doing each of these steps. Here's how we're getting to where we really need to be. As far as thinking about interventions, like I mentioned before, we don't really have an intervention. So what we're working on right now is that first phase of data collection and then finding a way to make this a true CQI process. And so developing some sort of feedback loop, either through reports that we already exist and disseminate on a regular basis, or through creating new ones that would be kind of regularly distributed. The last thing that we want to talk about here are those in-sessions. What have we changed? I think Scott had asked, what's changing given the current CIP funding level? There's obviously concerns, right? My job title is Research and Evaluation Specialist, and without that grant, we don't know what that's going to mean for our team in the long run, and who's going to be doing some of the, especially the analysis component. But, fingers crossed, we will find a way to make that work. As far as scaling back, getting to our courtrooms is a big issue. Nebraska is a large state, and our office is very far on one side of the state. So to get out to some of greater Nebraska, we have up to 6 or 7 hours of travel one way to get to some of our significant courtrooms where, there has been expressed concern that we should go out that way. Which is why we're, again, really excited about that foster care review office partnership and working with them in hopes that we can do some work with them and we don't have to have that expenditure and can get to those areas. The other really important thing that we would want to share about our hearing quality effort is that we did a lot of upfront work on validating our tool. We're talking months of upfront work, validating our tool, making sure we were measuring what we wanted to measure. On our engagement and hearing quality, or our engagement scores, we used to use a 5-point scale, and we found that when we did that, we weren't getting the consistency we liked, so we had to reduce that to a 3-point scale and kind of retrain everybody who was doing court observation, and we were able to really get to a place where we felt like our measurements were reliable and valid. I also spent a lot of time writing a procedures manual and code book so that we have a written document that shows here's what you're measuring, here's how you evaluate it, and here's how you then enter it into a data system. We'll use Excel, and then I'll use SPSS to do the analysis. But this way we can rely on other people to enter the data for us, and that information is all very clearly laid out And it was a lot of work. That code book and procedures manual is about 30 pages long, but I think it's kind of at least for me, a prized possession and a tool that is going to make sure that we are on the right track with this project as we move forward. Anything else, Marianne?
I think you covered it.
Scott, anything else you'd like me to touch on?
No, I would open it up for questions to the group. Again, it's *6 if anybody wants to ask, or we can put it in chat.
Scott, this is Tim in Oklahoma. I was just wondering if they have their tool on CIP Share so that others could look at that.
Their court observation tool.
Yeah, the court observation tool.
You know, we were just talking about that. I don't think we do yet, but I will go ahead and get that up there along with the code book as soon as we're done with this call.
Thank you.
Not hearing anything else or seeing, oh, well, now I see somebody is typing. Okay, well, Andy is saying if you can email him, he can upload it right now. Thank you.
Perfect.
And
I
think
will do
we
that.
can, again, yes, go ahead. Okay, great. So let's move on to Oklahoma. And you should be able to move that around, Tim and Felice.
Okay.
Can you briefly say, what is your hearing quality project?
Okay, so our hearing quality project is the Oklahoma Juvenile Uniform Orders. And I guess what people can see on their screen is just a copy of the permanency review order, and we'll look at that a little bit more in a bit. But these orders encompass emergency custody hearings through orders terminating the court's jurisdiction over children. Those orders include necessary statutory findings that can also be used as sort of a bench card for conducting hearings.
Okay, so backing up, when and why did you start working on this in your state?
Hi, Scott. This is Felice. The uniform orders were originally born out of the Kelsey Smith-Briggs Act, which was an act that happened in 2006 as a result of a child death in Oklahoma. Also, the Child and Family Services Review noted a lot of inconsistencies across the state with the way cases and court hearings were documented. So the Kelsey Smith-Briggs Act required judges to use uniform forms for their orders that include space for noting recommendations made by those who appear at the hearing. And this makes the judges more accountable for their rulings.
And initially, what outcomes did you hope to improve? Or did that act hope to improve?
It wanted to, again, capture the breadth of the hearings and in a form that's documented uniformly across the state. In this particular case, the judge had made a ruling, but it wasn't documented, and so this child was returned home, and so there were a lot of finger pointing at each other. And so the legislator came out and said, we just need to have uniform orders. So the Juvenile Justice Oversight and Advisory Committee got together and established these orders in 2007.
Can you tell us about the teams that you had to form to get this work done? So,
Scott, this is Tim again. We had the original orders involved our Juvenile Justice Oversight and Advisory Committee. It also included people from the DA's Council and I believe DHS. We've spent the last 2 years revising those orders and updating those. And so most of that work was done through our Juvenile Justice Oversight and Advisory Committee, a subcommittee of that. But then we also, other team members involved in that is our performance measures work group.
As I said, with CFSRs, when they would go through and look at the files, they did not find any consistencies, and so that was the idea behind creating these orders. Of course, we know that the handwriting. I mean, this is just a real simple thing, but a lot of times the judges have horrendous handwriting, and so it was really hard to document what they were saying. And so the uniform orders have everything in a typed manner, and you will go through that in just a moment. Tim will go through that with you.
So I guess, yeah, and some of these new orders, and I guess let me just jump into those, maybe the easiest way, and stop me or rein me in if you need to. So if we're looking at quality hearing, I'm going to go back to the front page. The orders give us a place to show who all was at this particular hearing. The bottom of the page, we've added this. It's the date that the minor children were placed out of the home. So in reviewing that order, you can do some quick calculations to see how long this case has been open. And then some of that other information. So like on the reasonable efforts findings, at the end of this part that's highlighted in green, there are several places throughout the orders now where we give the courts a place where they can actually document whether it was the reasonable efforts that were made. Coming down into ICWA, you're going to find, again, what were the active efforts that were made. There are things dealing with educational needs, things with visitation. Again, it just expands the space to enter everything that happens in the hearing, and lets the order itself kind of tell the story of what's going on in the case.
I guess I'm guessing is that what you have here is that by filling everything out in the order, the breadth of the order, you're anticipating better decision making. That's where how you connect to those outcomes.
Right. Right. So you're having a more thorough hearing. The information's being documented in there, with a couple of the formats that we use, whether it's a Word document or it's an Excel document. Some of that information can be continued into the next permanency review hearing. You can see what's happened in the past. Where you're trying to head. You're capturing that information and allowing for some better data collection.
So in other words, this is your intervention and your data collection tool.
Correct. Okay. And since with the data collection, if you'll notice at the bottom of each page, if I get this to stop, there are docket codes used within one of our case management systems that are placed on the bottom of each of these orders. And so there's been some inconsistency across our state in the use of the correct codes. These particular codes are OCIS system. That system's used only in 13 of our counties, but that covers over 53% of all of our juvenile deprived cases in the state. And for us, it's the one place where we can actually work to collect some data. We've got some reports created that help us to review that, but it also allows judges to look at their cases and pull some quick information up for their own management of their cases.
That's one challenge, consistency across the state. Are there other challenges that you've been able to overcome or are still fighting?
Well, I think a challenge that everyone will always find challenging is the independence of the judges. They want to do things their way, and it's their courtroom, and they have that right. Initially, when these first rolled out in 2007, we had a strong contingency of judges saying, number one, the legislature can't tell them what to do, and number two, they document the case any way they want to. Since that time, and through a lot of training and persistence and the backing of the Supreme Court, they've the majority of the courts have come around to accepting the uniform orders and accepting the, the usefulness of them. So I think that will continue to be a challenge because you'll always have those that will hold out. But I think with training, Tim has done a really good job with training not only the judges this past fall, but the court clerks and how to enter the proper code so we can get the data from the reports. So that's going to be something that's ongoing. It's not going to be a one-hit thing. It's something that we have to keep doing. We have to keep putting it out there, letting them know why it's important, and setting up the continuous training. Tim is also doing, has just put together trainings for online that they can just access from their computers, and he just goes through the uniform orders with them that way. So
those are training videos?
Yeah, the podcast type thing.
Right. I think we actually locate those on a private YouTube channel. We have one that we'll use again just to get back out to all of the courts, and it can also go out to ADAs and attorneys, just kind of going over, why these uniform orders are required, where they can find them, how they can use them. And then we're working on a couple of training videos that will have someone actually going through and completing those orders as though they were in a hearing. Some of our largest courts have staff that complete those orders, type those orders out while they're in court. The judge has a screen on the bench where he or she is actually watching what's being entered, making sure that information is correct, and then they're actually able to print those off, file those, and hand out copies to parents and other participants before they leave the courtroom. So, we're hoping that by having that and more thorough information, parents are going to know exactly, what it is that they're expected to do or what DHS is expected to do prior to the next hearing. Like I said, if they've changed visitation, adding more visitation. But the participants will have a copy of that in hand before they leave the court. Right. And it also affects notice. That was another thing that the Supreme Court had us added a whole back page, showing that notice had been given, and, because there have been a couple of cases that have been remanded because people didn't have notice of hearing.
All right. Is there anything else that's important to highlight about your project? Okay.
No, we're open to any questions.
Yeah.
Don't have anything else.
Well, let's move on to open space Q&A. So now again, it's *6 to unmute. Questions for Nebraska or Oklahoma or for anybody else. We have a lot of other people on the call who have worked on hearing quality. So *6 to unmute or in chat. Well, if we have no questions, any comments, anything you wanted to share?
Hey, this is Alicia. I just have a question for the field. The research that we have is good, but it's limited. It has both methodological limitations and then application limitations, but I think this is an important area, and since it's one that a lot of people are going to be working on, my question to you would be, what is it that you'd like to know about hearing quality and outcome?
Alicia, this is Tim in Oklahoma again. Since we have so many people listening, one of our issues, these uniform orders, some of them are 8 pages long, and that's part of the pushback we get from courts and people making copies of those. We have been trying to find out if anyone knows of a web-based form generator, something that could be used that would where these orders could be completed, the parts of the orders that are completed or maybe all that print, but then would also allow you to do some other forms of data collection in the background.
Hi, this is Don in California. We use a program like that to produce family court findings and orders. It's, and I'm blanking on the name, but it's available through the legal services community. They have developed it and make it available at nominal cost. I'll find the information and send it to Scott.
Thank you.
Thanks, Don.
Anyone else have any thoughts or questions before we move on to the final polls? This is maybe a little bit broader, but could include the last question. What additional guidance or products would you like from the CBCC to help you with hearing quality? That is open-ended question to the left. And as always, we're just interested in how useful any call or anything is. That's the multiple choice there at the right. And thank you for coming today. There's nothing else. Safe travels if you're traveling and all that. Stay warm.